Hello guys, welcome to my next Monday Bible episode. My today guest is Giovanni Maria Riccio, professor of comparative law at Salerno University and partner at Alex Law Firm from Rome. Giovanni, it's great you could join me.
Thank you very much for the invitation, Michael, and great to see you again.
We are here to discuss current state of AI's impact on IP rights in the EU, particularly regarding copyrights. Maybe at the beginning, let's start with some general overview.
I think that we have a problem, which is the fact that all the contents are scanned by artificial intelligence machines, that these machines are trained through contents which are often protected by copyright. And this is an issue. We should find a way to find a solution. The point is that we have a regulation, at least in Europe, but this regulation, it's arguable that it covers exactly the artificial intelligence.
You probably mean the exemptions from copyright directive. What do you think about these exemptions?
The copyright directive for the single market of 2019 provides two articles, Article 3 and Article 4, which regulate the text and data mining exception. There is a difference between these articles. Article 3 is mainly devoted to the use of text and data mining for scientific research and cultural institutions. Article 4 covers also the commercial uses. The European regulator, as for Article 4, has introduced an opt-out in the sense that if you are a copyright holder, you may ask not to be scanned, in the sense that the artificial intelligence machine cannot use your content, and so the content which is protected by your copyright. We have to take into account that the technological scenario has dramatically changed from 2019 or even from 2017, 2016, when the debate regarding text and data mining started. We have new technologies. As you said, there are exceptions to copyright and to the reproduction of the use on the one sense, and also to the use of database on the other sense, as a sui generis right. But we are not sure that this is the best solution. Also, in terms of economy, we have to consider that we are facing a globalized economy, and to consider if this can regulate efficiently or not, and if some change should be done. Also, we should consider that the not yet approved artificial intelligence regulation does not contain any rules which are devoted to copyright. We only have some rules on the transparency. Probably we will discuss this later, but we do not have any regulation on copyright. I'm not arguing that there is a good solution and a bad solution, but probably we need a specific regulation for copyright and artificial intelligence.
I think the same. I don't know if you are aware of all these copyright shields that are now provided by Microsoft, IBM, OpenAI. And so I think they also see the problem of scrapped data, protected copyrights being used to data mining. So I don't know if it's the focus of the shields is US more and this fair use approach than Europe, but also in Europe we should reconsider the approach.
Yeah, this is a great topic, actually, because in general, the American scholars have pointed out that probably the fair use doctrine would cover and will protect also the commercial uses made by the artificial intelligence. Probably if we look at this aspect also in a non-strictly legal approach, we should also consider that at the beginning of the so-called new economy, and mostly with the rise of the Web 2.0, and so the rise of the social media platforms like YouTube, like Facebook, and whatsoever, we have faced to a completely different approach from Europe and US. The American legislation was and still is much more permissive, and it allowed the growth of these social media platforms. In the case of copyright and artificial intelligence, I see the same approach. I think that when we consider the regulation, we should also consider the political aspects and the economic aspects which are behind these regulations. We should also take into account the silent war between China and the US on artificial intelligence.
It's about inputs and data used for training of artificial intelligence. What about outputs? Should they be protected by copyright?
As for the outputs, I think that we may adopt a different approach based on the current regulations and based on the regulation which could be. What I want to say is that we do not have a definition in European law on the figure of the author. Yes, we have some references in the InfoSoc directive and in some further directives. The author of the work is generally considered a human being, but we should also consider if there could be any works produced by non-humans. It's something which is related more with the philosophy of law than to copyright. But if we want to see the current regulations, in general, according to the Court of Justice, from the InfoPac decision, copyright work is an intellectual creation of its author. So it means that it implies that it is created by a human being. We also know that U.S. Copyright Office has denied copyright protection for works which were totally created by the artificial intelligence. So this is quite clear. There's also a decision made by the District Court of Columbia, just stating that if a work is completely created by a machine, then it cannot be covered by copyright protection, regardless of the copyright owner. So if it is a machine in the future, if it is the developer, if it is the producer, in the sense the one who make investments. I would also remind that there is an interesting decision in Italy of the Italian Court of Cassation, the Supreme Court of Italy, which is of the January of 2023. The decision, if you are interested to read it, is the number 1107. The case was about a flower which was created with the aid of an artificial intelligence software. And it has been considered as protected by copyright because the human intervention and so the human contribution is still identifiable. This is also another aspect which is not easy to solve, the degree of this cooperation of human beings as for the machines. We already have many works which are protected, even if they use, for example, the presets. Also the music, for example, we have the pre-recorded patterns. They are used in many songs. There is an interesting video with Damon Albarn from Blur and from Gorillaz, and he explains that he has created one of the most famous songs of Gorillaz, Clint Eastwood, using the patterns which are included into a very small keyboards. So in this sense, there is also the contribution made by Damon Albarn into the creation of this song, but you have a pre-pattern which has been used into the work itself.
It's very interesting. I have had such discussions with law philosophers like David Gunkel, who thinks we should recognize the rights of robots and AI systems. I had also a discussion with attorney from Ukraine, where they have a separate right that is not copyright, but a right to the object, not the work. So if something is created by the machine only, it's a separate type of right that can be possessed by the human being, by the owner of the system. So the solutions are starting to happen. So should we change the law right now when AI comes and changes the style of our job over our works over copyrights, or should we reinterpret the law?
Well, I think that both the positions are very interesting. I do agree with David in the sense that probably we should consider for the future also the possibility of granting to rights to robots. The second aspect is also interesting, at least to me, in the sense that probably when we consider the copyright protection, the first question that we have to pose is copyright the right solution? In the sense that we have to consider that a very general starting point is that the law is a selection of different interests, and also that copyright protects creativity. If the protection is not related to creativity in the sense that an artificial intelligence machine may create in a few seconds many works. So in this case, what are the interests that we are currently protecting? In this sense, I do agree with you. Is copyright the right solution? Probably not. Probably we should consider also some related rights, ancillary rights for this kind of creations. And also, we have to consider probably something which is new. So, the use of these works. It has been already proposed to consider different licenses and different fees, for example, for the use of the reproduction of musical works on Spotify. If I listen to Talking Heads, for example, or if I listen to the yoga playlist, which is not so artistic as something made by David Byrne and by Tolkien Heads, probably. It is not a matter of quality. Copyright does not protect quality, of course. It is a matter of the way in which the effort to create these works. So probably we should also reconsider the doctrine of common law of regarding the sweeting, and so the effort that you do in the creation of the work. It has not been considered a lot by the Court of Justice, but probably we should consider the creative effort in the creation of a musical or in general of artistic works.
So one more question, moving to AI Act. How do you think that it might impact IP protection? You already said that it's not mentioning a lot IP rights.
There is a new provision in the Artificial Intelligence Act, which has been added regarding the transparency of the machine and most of all the transparency in the training activities made by the machines. This is not clear anyway how it will work, which are the limit of the transparency, which are the boundaries of this transparency obligation. I think that it is very important to consider. Probably it could be a good basis for negotiating licenses between copyright collecting societies and the producer of artificial intelligence. We have to consider that it is too expensive for a single author to check the single uses of his works. So probably this work will be made by copyright collecting societies, which will negotiate licenses with artificial intelligence producers. This is very interesting in the sense that we have to find some way of remuneration for authors, and so this could be a first step at least.
Thank you very much. There are many more things to be discussed, but Giovanni, thank you for giving us some light on these problems, and thank you for being here.
Thank you, Michael. Thank you very much. It was a pleasure.